So firstly, we will try and understand the meaning of dispute settlement. Dispute means verbal controversy, contest by opposing argument or expression of opposing views or claims. A settlement is a resolution between disputing parties about a legal case reached either before or after court action begins. And the procedure used to settle disputes, that is, to come out at a decision by discussion, is called dispute settlement. Various types of disputes are strike, lockout, gherao, picketing, and boycott. Stoppage of work by employees, often as members of a trade union, to obtain or resist change in wages, hours, or conditions is called strike. It is a collective stoppage of work by a group of workers for pressuring their employers to accept certain demands. Strikes may be official, union authorized, or wildcat, undertaken spontaneously, and may be accompanied by a sit-in or work-in, the one being worker occupation of a factory and the other continuation of work in a plant the employer wishes to close. In a sympathetic strike, action is in support of other workers on strike elsewhere, possibly in a different industry. A general strike is action by members of several key industries that aims to halt a country's economic activity. Lockout is different from a strike in which employees refuse to work. A lockout may happen for several reasons. When only part of a trade union votes to strike, the purpose of a lockout is to put pressure on a union by reducing the number of members who are able to work. Gherao means encirclement, is a word originally derived from Bengali and is a typically South Asian way of protest. Usually a group of people would surround a politician or a government building until their demands are met or answers given. This principle was introduced as a formal means of protest in the labor sector by Subodh Banerjee. Picketing is a form of protest in which people, called picketeers, congregate outside a place of work or location where an event is taking place. Often this is done in an attempt to dissuade others from going in, but it can also be done to draw public attention to a cause. Picketeers normally endeavor to be non-violent. After studying this lesson, you will be able to enumerate the types and causes of disputes, discuss the dispute settlement machinery, understand the concept of adjudication, analyze the concept of lok adalats, analyze the given case laws. Now it is time to know about the causes for disputes. The causes of industrial disputes can be broadly classified into two categories: economic and non-economic causes. The economic causes will include issues relating to compensation like wages, bonus, allowance, and conditions for work, working hours, leave and holidays without pay, unjust layoffs, and retrenchments. The non-economic factors will include victimization of workers, ill treatment by staff members, sympathetic strikes, political factors, indiscipline, etc. Wages and allowance. Since the cost of living index is increasing, workers generally bargain for higher wages to meet the rising cost of living index and to increase their standards of living. In 2005, wages and allowances accounted for 21.8% of disputes. Personnel and retrenchment. The personnel and retrenchment have also been an important factor which accounted for disputes. In the year 2005, only 9.6% of the disputes were caused by personnel and only 0.4% were caused by retrenchment. Indiscipline and violence. It is evident that the number of disputes caused by indiscipline has an increasing trend. In 2005, 40.4% and 41.6% of disputes were caused due to indiscipline and violence respectively. Bonus. Bonus has always been an important factor in industrial disputes. 6.7% of the disputes were because of bonus in 2002 and 2003 as compared to 3.5% and 3.6% in 2004 and 2005 respectively. Leave and working hours. Leaves and working hours have not been so important causes of industrial disputes. During 2004, only 0.4% of the disputes were because of leaves and working hours. Miscellaneous. The miscellaneous factors include inter- or intra-union rivalry, charter of demands, workload, standing orders or rules or service conditions or safety measures, non-implementation of agreements and awards, etc. Now let's discuss how we can settle the dispute. It can be settled by two machineries, statutory machinery and voluntary machinery, or preventive machinery. Statutory machinery is also called settlement machinery, while voluntary machinery is also called preventive machinery. We have all heard that prevention is better than cure. Thus, let's first discuss preventive machinery before settlement machinery. The measures that can be taken to prevent disputes in the industry are code of conduct, workers' participation, collective bargaining, joint consultation machinery. The first one says that every organization should make and then abide by the code of conduct. For this code of conduct were made applicable to industry and workers from June 1, 1958. It aims at preventing disputes through negotiations without the interference of an outside agency. The main elements of the code are: the two parties agree to utilize the existing machinery for the settlement of industrial disputes. The parties shall not resort to strikes and lockouts without first exploring all avenues of settlement. The parties accept that disputes not settled mutually shall be referred to voluntary arbitration. The code specifies the criteria for the recognition of trade union and creates an obligation on employers to recognize the majority union in an establishment or industry. The two parties shall not resort to the unfair labor practices detailed in the code. Managements and trade unions agree to establish grievance procedures on a mutually agreed basis. Another one is workers' participation, which provides a ground for communication and increases morale, which leads to mental revolution in both minds. Collective bargaining is also one method to prevent disputes, and if occurs, then can be resolved outside the judicial authority control without leading any effect on relation between employer and employee. Last but not the least is joint consultation, which is a process whereby employer consults the workers either directly or through their representatives and seeks their opinion on various issues while retaining to himself the right of taking final decisions. It is carried out through joint consultation committees consisting of the representatives of both the employer and workers. Now let's study statutory machinery. Authorities under this Act are Works Committee, Conciliation Officers, Boards of Conciliation, Labor Courts, Industrial Tribunals, National Tribunals. First one is the Work Committee. Every industrial undertaking employing 100 or more workers is under an obligation to set up a Works Committee consisting of equal number of representatives of employer and employees. The main purpose of such committees is to promote industrial relations. According to the Indian Labour Conference, work committees are concerned with administration of welfare and fine funds, educational and recreational activities, safety and accident prevention, occupational diseases and protective equipment, conditions of work such as ventilation, lighting, temperature, and sanitation. Next is Conciliation Officer, means a conciliation officer appointed under this Act. The appropriate government may by notification in the official gazette appoint conciliation officers. These officers are charged with the duty of mediating in and promoting the settlement of industrial disputes. The appropriate government may appoint one or more conciliation officers as it thinks fit, which is called Board of Conciliation Officer. The appointment may be made either permanently or for a limited period. In Delhi, there are industrial tribunals and labor courts. These courts are presided over by officers from Delhi Higher Judicial Service. Majority of disputes are referred to these courts by the government after receiving failure report from the conciliation officers, but some of the disputes can be directly raised before the courts by the aggrieved parties. Industrial tribunals are independent judicial bodies that hear and determine claims to do with employment matters. These include a range of claims relating to unfair dismissal, breach of contract, wages or other payments, as well as discrimination on the grounds of sex, race, disability, sexual orientation, age, part-time working, or equal pay. National tribunals are constituted by the central government for the adjudication of industrial disputes, which, in the opinion of the central government, involve questions of national importance or are of such a nature that industrial establishments situated in more than one state are likely to be interested in or affected by such. Lok adalats play a significant role in resolving the dispute, which we can study here. Lok adalat is a system of alternative dispute resolution developed in India. It roughly means people's court. Lok Adalat is a non-adversarial system whereby mock courts called Lok Adalats are held by the state authority, district authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, or Taluk Legal Services Committee. They are held periodically for exercising such jurisdiction as they determine. These are usually presided over by retired judges, social activists, or other members of the legal profession. It does, however, not have jurisdiction on matters related to non-compoundable offenses. There are many limitations associated with litigation. Litigation involves a lot of delay. It is expensive. In India, the adversary method of dispute resolution is used in litigation. The adversary method is one which gives the parties and their lawyers a great deal of control over the way in which the facts are collected and presented. Each party will present the evidence to the court in a way most favorable to its own version of the facts and adverse to that of the other party. This is not a good way of resolving disputes in situations such as family relations or industrial relations where human emotions are also involved. In view of the limitations of the adversary method regarding dispute resolution in areas where human emotions are also involved, the advantages of mediation as a method of dispute resolution have been seriously considered. There are neither court fees nor any rigid procedural requirements which speeds up the process. Parties can directly interact with the judge, which is not allowed in regular courts. The Lok Adalat is set up under the Legal Services Authorities Act 1987. Part of the move to make available wider access to justice, they aimed at providing that prompt and inexpensive justice to the poor. The award of Lok Adalat is based on mutual agreement between two parties. India has had a long history of resolving disputes through the mediation of village elders. The system of Lok Adalats is an improvement and is based on the principles of Mahatma Gandhi. The first Lok Adalat was held in Chennai in 1986. In order to get over the major drawback in the existing scheme of organization of Lok Adalats under Chapter 6 of the Legal Services Authorities Act 1987, in which, if the parties do not arrive at any compromise or settlement, the unsettled case is either returned back to the court of law or the parties are advised to seek remedy in a court of law, which causes unnecessary delay in dispensation of justice. Chapter 6A was introduced in the Legal Services Authorities Act 1987 by Act No. 37 by 2002 with effect from 11/06/2002, providing for a permanent Lok Adalat to deal with pre-litigation, conciliation and settlement of disputes related to public utility services as defined under Section 22A of the Legal Services Authorities Act 1987 at pre-litigation stage itself, which would result in reducing the workload of the regular courts to a great extent. But the newly set up Lok Adalat of Narega is facing a range of anomalies in the process as well. For the most part, it is flooded with complaints based on misinformation or rather disinformation. Secondly, some of the benches lack credibility. Thus, this method is also being continuously distorting. To fully understand what dispute settlement is, we can discuss some cases also, which are illegal strikes, the Industrial Disputes Act 1947, termination, the Industrial Disputes Act 1947, retrenchment, the Industrial Disputes Act 1947. A case law is the available writings explaining the verdicts in a case. Case laws depict how a labor court or industrial court or high court or supreme court interprets various labor legislations and therefore can be cited as precedents. Case law is often created by judges in their rulings when they write their decisions and give the reasoning behind them, as well as citing precedents in other cases and statutes that had a bearing on their decision. As per the Act, a strike or a lockout shall be illegal if 1. It is commenced or declared in contravention of Section 22 or Section 23. It is continued in contravention of an order made under subsection 3 of Section 10 or subsection 4A of Section 10A. The case in reference to this Act was the case of management of Coimbatore District Central Cooperative Bank versus Secretary, Coimbatore District Central Cooperative Bank Employees Association, and another, and the date of judgment was 23/04/2007. Being aggrieved by the award passed by the Labour Court, the union approached the High Court by filing a writ petition. The learned single judge did not disagree with the findings recorded by the Labour Court and held that the workmen were not entitled to wages for the period they had not worked. As to the second punishment, the management was directed to pay the arrears in respect of stoppage of increments to the workmen with interest at the rate of 12% per annum within 60 days from the date of receipt of the copy of the order. The second case was of Director Food and Supplies Punjab, another versus Gurmeet Singh, and the date of judgment was 17/04/2007, which can be discussed under the reference of termination, the Industrial Disputes Act 1947. Termination of employment is the end of an employee's duration with an employer. Depending on the case, the decision may be made by the employee, the employer, or mutually agreed upon by both. The case of the workman was that he joined the present appellants as Chowkidar and worked therein from 1/6/1985 to 24/8/1986. His services were terminated on 25/8/1986 by the management without service of any notice, holding of an inquiry or payment of any compensation. He was getting rupees 400 per month at that time as wages. He is covered under the Industrial Employment Standing Orders Act 1946, in short, the Standing Orders Act. The management did not comply with the principles of natural justice while terminating his services. The notice of reference was given to the present appellants. It was stated in the written statement inter alia that the claimant was working as Chowkidar on daily wages. His services ended with the end of each working day. The claim of the claimant that he had worked from 1/6/1986 to 24/8/1986 is not correct. The matter is remitted to the Labour Court to adjudicate on these aspects. Since the matter is pending since long, the Labour Court would do well to dispose of the matter within 4 months from the date of receipt of this order. The third case is of Madhya Pradesh Administration versus Tribhuvan, where the date of judgment was 05/04/2007. This is in reference to retrenchment, the Industrial Disputes Act 1947. State of Madhya Pradesh runs an establishment in Delhi known as Madhya Pradesh Bhavan. Respondent was appointed on temporary basis from time to time with breaks in services. He worked for the period 13/12/1991 to 1/3/1994. After his services were terminated, an industrial dispute was raised. The said dispute was referred for its determination before the Industrial Tribunal. The Industrial Tribunal, by an award dated 26/7/2002, while holding that in terminating the services of the respondents, the appellant has failed to comply with the statutory requirements contained in Section 25F of the Industrial Disputes Act, awarded only retrenchment compensation along with notice paid together with interest at the rate 9% per annum. Validity of the said award was not questioned by the appellant. In this case, the Industrial Court exercised its discretionary jurisdiction under Section 11A of the Industrial Disputes Act. It merely directed the amount of compensation to which the respondent was entitled to. Had the provisions of Section 25F been complied with, should be sufficient to meet the end. Now let us check if we have understood the various concepts discussed in this lesson clearly. Stoppage of work by employees, often as members of a trade union, to obtain or resist change in wages, hours, or conditions is called strike. Right or wrong? Right. Lockout is different from a strike in which employers refuse to give work. Right or wrong? Wrong. Every industrial undertaking employing 100 or more workers is under an obligation to set up a works committee. Right or wrong? Right. Now let's revise the whole concept. Industrial disputes constitute militant and organized protests against existing industrial conditions. Industrial disputes may take up various forms like strikes and lockouts, gherao, picketing, and boycott. Industrial disputes arise due to several causes relating to recognition, retrenchment, employment conditions, indiscipline, wages and allowances, bonus, ill treatment, etc. Strong trade unions, work committees, joint management councils, standing orders, proper grievance procedures, code of discipline, collective bargaining, etc. help in preventing industrial disputes. Conciliation, conciliation officer and board of conciliation, arbitration, voluntary and compulsory, and adjudication, labor court, industrial tribunal, national tribunal help in the settlement of dispute as envisaged by the Industrial Disputes Act. Thank you.